The CPI report, Child Protection in Iowa, is brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Sunday afternoon at 1 o'clock. And again, it's repeated on Wednesday evening at 9:30 here in Des Moines on Mediacom Cable Channel 15. You can email us at vocaliowa@mchsi.com. My telephone number is area code 515-276-3956. John's number is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. Yes, we do like to talk to individuals who are having difficulties with the Department of Human Services and the juvenile court as well. And we have some assistance here regarding court issues in the form of a court consultant, Terrance Walker. And we're pleased that he has come on board to bring a message from time to time. You know, we've mentioned to you from time to time, or in the last couple of sessions, a little missing boy. We're certainly going to miss this young man. His name is John Allen Jensen. John Allen Jensen is an 8-year-old that you may have heard about in the news who was lost by drowning in a swift creek called Soldier Creek in Fort Dodge. He was swimming, actually tubing, with his brother in this rapidly moving creek, and apparently nobody really realized the danger that lurks in swollen waters of that sort. And while we can't point fingers, we kind of, you know, there still is a question as to whether it was wise to permit boys to swim in a creek. This creek is usually a very gentle creek and is very inviting to young boys. But at the same time, his father, John's father, was at a picnic not long ago, and the boys asked to go somewhere, and the father said, "No, I want you to stay in view." Well, that's probably a good idea. Maybe cautious, but a good idea when you have boys that are ages 8 and 10, and boys usually like to be somewhat adventuresome. These boys wanted to run around Walnut Woods State Park, but since father wasn't familiar with the park and didn't have time to go with them, he said that they should stay inside. That's probably good advice for children to stay in view of their parents. We don't know why, in the case of these boys, adventuresome in adventuring out away from direct supervision in the park near Soldier Creek, why they managed to get away from close supervision, but one wonders why that should have happened. Well, we've got another view, Don, here, if we can locate it.
Let me make a comment about the park you originally talked about, where the father said he told the boys, "Now don't wander out of my eyesight." The reason why he was there, and I was there, I mentioned it, I think, on our TV program, that parents got together that had lost their children to the Department of Human Services. And so we had a picnic down there, and we had a couple speakers. And so that's why we were down there, and he had brought his 2 boys down there that he had previously lost to the DHS, but in the past year he had got them back. Okay, John?
Yes, he's had more than his share of interaction with the Department of Human services. Jeff Jennison numbers among 100,000 fathers in the state of Iowa whose family has been broken up, and he's remarried, and I want to show you his newest son. This little boy, his name is Joshua Allen Jennison, and he was born the 7th day of June. Jeff Jennison is a pretty proud father, and he had his little boy at the memorial services when Don and I went to those memorial services. Those memorial services were attended by many rescue workers who lined the back of the room, but they were also attended by DHS workers, and we couldn't figure out for sure why DHS would be so involved in this case.
There's a verse in the Bible that says, I'm not sure if I can quote it. The Lord giveth, the Lord giveth and the Lord taketh away. Well, we see the DHS taketh away after the Lord giveth, and then here nature taketh away in a drowning. John?
Terrance has told us some stories about what happens in the stupid judiciary. Don has a story that we could probably put in the stupid judiciary department, but this story also has a second major theme, and the second major theme in this story has to do with the way we look at crimes against children, and the fact that even in Iowa, a crime against a child is considered a sexual crime. If you stole a nickel from your teenager, that would be a sexual crime. And why we codify our laws in such a fashion as this, I sure don't know. That means that if you're convicted of a crime against a child, you can be placed on the sexual offenders registry, which is really stupid. Well, let's listen to the story and see if you would classify this as a stupid judiciary. Don?
Okay. He starts out with saying, reprimanding a careless kid is a crime. How many parents reprimand their children when they make a mistake? This is written by John Carlson, Register columnist, published July 6th of this year. You might think things have gone a bit wacky lately on the courts and crime beats. And he goes on to say, there's a case of a fellow named Fitzroy Barnaby who would likely make Adams, Jefferson, and Madison, those are our ex-presidents, laugh out loud or cry. Pretend for a minute you're the unlucky Mr. Barnaby. You're driving down the street obeying traffic laws and generally being a good citizen when some idiot kid wanders into traffic. You slam on the brakes and swerve, missing the kid and leaving a puddle on the car seat. You have two choices. You can shut up, drive home 5 miles an hour, and have a stiff belt. I asked some questions a little bit ago on what that means, a stiff belt. You can go home and have a drink to cover up your feelings, I guess. A stiff belt. Or you can take a moment to tell the kid how she almost got herself killed and ruined your life forever. It would be a shocking experience when you have to try to divert an accident driving around a kid that runs out in front of you. Sometimes you can do it and sometimes not. It's like deer, I understand, at night when you're traveling. Truckers tell me that if a deer comes out in front of you, you don't want to swerve because you're going to hit the deer one way or another, and if you swerve, you'll have a wreck. In this case, you sure, I don't know what you want to do. You want to hit the brakes, if at all possible, for sure. Well, he goes on and says, you, you're better off going with the first option, considering what happened to Barnaby, who went with the second option. Oh, it has to get better here, because he took a second option. This is because the 20-year-old Evansville, Illinois man ended up, and this is no joke, being officially branded a sex offender. How can you tell a child that they're doing wrong and ended up be branded as a sex offender? You lose in court, in other words, and you're judged a sex offender. He goes on. The facts, as reported in the Chicago Sun-Times, shows an angry Barnaby called to the 14-year-old he'd nearly run down, yelling, "Come here, little girl." Well, if she's a little ways away, he's got to raise his voice to get her attention. He then got out of his car, took her by the arm, and gave her a lecture about how stepping in front of a vehicle is a very bad idea. Whether it's a big semi-truck coming down the road or just a car, that's a bad idea. The girl ran away, complained to police. Yeah, children don't like to be disciplined. And Barnaby was charged with, again, no joke, attempted kidnapping and child abduction. This is even though he didn't attempt to take the girl anywhere. Barnaby beat those charges. He was, however, convicted of an unlawful restraint of a minor. And in Illinois, that is considered a sex offense. That means even though he didn't do anything to the kid other than take her by the arm and give her a lecture that might end up saving her life, he must register as a sex offender. He is prohibited from living near a park or a school and must keep local police advised as to his place of residence. And then you got people whispering, "Hey, there's a sex offender. Stay away from him." He goes on. He might even get his name and picture in the local newspaper. To advise, I got to turn the page here. To advise neighbors they're living near a sex offender. How is that possible, you ask? Well, a spokesman in the prosecutor's office said the guy should be considered a sex offender because of the I'm not sure of that word.
Proclivity.
Proclivity? They never taught me that word in school. Of course, I guess I haven't been to school for years.
You're not supposed to have any proclivities in school.
Oh, really?
You're supposed to leave those at home.
Because of the proclivity of offenders who restrain children to also commit sex acts or other crimes against them. Well, what does proclivity mean, did you say? You don't know either?
I didn't say.
Oh.
I said you should leave them at home.
Because of the proclivity of offenders who restrain children to also commit sex acts or other crimes against them. Now we'll let the Appellate Court of Illinois, which upheld this insanity last week, explain itself. A little bit ago I was thinking, you can be a good Samaritan and still be found guilty this day and age. You remember the Good Samaritan story in the Bible, how somebody took time to help somebody in need. Here a person took time to explain the need to stay out of the street, and now he's got a lot of problems. While it may well be unfair for Barnaby to suffer the stigmatization of being labeled a sex offender when his crime was not sexually motivated, grabbing a kid is often a precursor, or prior to a child being molested, the court said. Well, that's how they get fathers, sometimes mothers, by the DHS. You can never do anything right in their sight. It's a wonder a child ever grows up and survive coming through the growing up years when he has to live with father and mother, isn't it? Well, anyway, he says, it is Barnaby's actions which have caused him to be stagnated, not the court, the ruling said. Trial court judge Patrick Morse even concluded Barnaby's only apparent intention was to chastise the girl. Well, he proved that in court, it sounds like. But the judge said, I can't read his mind. How about that? We'll find him guilty anyway, no matter what. Barnaby's lawyer, Frederick Cohn of Chicago, provided a succinct assessment of the situation. Well, I missed that word. S-U-C-C-I-N-T.
Succinct.
Succinct. What's that mean?
You have to leave that one at home too.
Boy.
No, it's short and to the point.
Short and to the point. Oh, assessment of the situation. So the lawyer provided a quick answer. This is the most stupid ruling the appellate court has rendered in years. Makes you wonder what Illinois' courts have done in years past to equal or top this one. Could this happen in Iowa? Well,
Sure.
Yes, I would say so.
really? I wonder how many other parents and other people here in Iowa have experienced that. And grandparents? Maybe. Say you hold a kid by the arm while you're chewing him out for tromping through your flower bed. You could be charged with false imprisonment. And the Iowa Code says a person convicted of any criminal offense against a minor has to register as a sex offender. Better to silently suffer the flattering flowers, as Barnaby learned. Anything can happen when you're hauled into a courtroom. According to a 2002 study by the Urban Institute in Washington, D.C.
You're in the wrong story.
Oh, let me
Okay.
tell you something that happened to me many years ago. Well, it didn't happen to me. I just saw a newspaper article. But it reminds me, first of all, I tell you, parents, fathers, be cautious on picking up your child, get myself behind my mic, and placing that child on your shoulders, letting the child ride on your shoulders. How many parents have done that? Well, I wouldn't recommend you tell DHS to do it. I never had a problem with DHS on that, but I know that DHS would just love to get you on that issue. But I remember going back down to Creston and saw the Creston News Advertiser, and lo and behold, they had a different drift. The DHS did, but the News Advertiser went out and took a picture of a father carrying his son, I believe it was, on his shoulders. And they were having a contest, the DHS was. And here DHS was saying, hey, this is the greatest thing. We'll give him a prize for, I don't know what the reason was, while he was carrying his child on his shoulders. But I'm here to warn you, parents, that DHS would love to write up an abuse report and take your child away from you for doing that. John?
Okay. There are several things that drift out, boil out of that story that you read just now, beyond the fact that that it is a stupid judiciary that fiddle fools around with definitions, and by grabbing a kid by the arm is sexual abuse, because the proclivities of those who are sexual abusers might be somehow related. Now that's a pretty lengthy stretch of the definition of sexual abuse.
And the Iowa Code, like this article says, goes on to state that any person convicted of any criminal offense against a minor has to register as a sex offender. Now, to me, that's a far-reaching definition. And it's
Criminal offense. What would be one?
anything can happen while you're in court.
Stealing a fishing rod, or any kind of theft, or even real minor. Is that correct?
That's ridiculous.
The one I was giving as an example here is if you broke your kid's piggy bank to get 15 cents out because you didn't have quite the right change to buy the pancakes to feed the family, that would be a theft from a kid. And
Well, that would be a sex offense.
and so that would be a sex offense. Now,
Wow.
you see, falling out of this are stupid definitions, and it also means that the name of this person has to be on the registry, which would be an offense against that person for the rest of his life, really, because the bulletins can be, his picture can be displayed, and he has restrictions about where he can live and that sort of thing. Now that is totally, totally ridiculous in our quest to protect children. And we say we have 6,000 offenders, sexual offenders. Well, I wonder how many of those 6,000 sexual offenders are ones who stole a nickel from their children, or did something that was certainly a lot less offensive than sexual abuse, but yet they call them sexual abusers. This just doesn't make sense. You had a comment there,
Yeah,
Terrance.
I just was going to say it would be kind of insane, but it's not hard to imagine that a guy like this who was trying to chastise a child and basically provide some parenting, because the parent wasn't obviously there, to warn the child not to be playing in the street and wandering off in the street. Lo and behold, probably months or maybe years down the line, he might have some crackpot show up at his door with a sign that says, "You're a sex offender, and you shouldn't be in my neighborhood, and we're going to kick you out, because you're too close to that park, And unbeknownst to them, the guy was just actually trying to warn the child to get out the street, but yet the insanity continues. And so saying this, I agree wholeheartedly with the columnist, end quote, that anything can happen when you're hauled into a courtroom.
And
That's
it's
right.
too bad maybe the parents aren't even instructing the child to stay out of the street.
Yeah, well,
Could be that side of the story too.
I believe the old adage, it takes a village to raise a child.
You do.
Yeah, whatever happened
What
to that in
happened to
this
that?
story?
Well, I guess we're supposed to just let the kid wander down the street and get hit by another car.
Well,
was that the
isn't
purpose and intent of the law?
isn't the
really
driver
don't
part of the
understand
village?
I really don't understand that.
Okay.
It would make sense to me if, there was some sort of provision put in place that would basically excuse such acts as these, so that the guy would not be held to answer for a criminal act. I mean, that's just ridiculous, And he almost hit the child. The child shouldn't have been in the street at that young of an age, wandering, obviously, and irresponsibly wandering into the street. But to say that the guy can't live near a school, can't live near a playground, and to stigmatize him as a sex offender, I think is wholly ridiculous.
I'll take.
Well, you touched on the point of my discussion here when I talked about the fallout from this, and the fallout. I think one of the major fallouts is, where was the supervision? Who was the person who was most apt to be the target of any lack of supervision, of any the target of any accusation of a lack of supervision? Where was the supervision that permitted this girl to run out in the street? Now, there's sometimes, if that mother has 3 or 4 children, that a 5-year-old can dart into the street, and there's really nothing much you can do about it. But it seems like to me that somewhere in this story, it was a 2-page story, there was no mention of anybody to supervise this 5-year-old. Apparently she was out there on her own. Now, the best guard against abuse of children is close supervision. Where was the father at Walnut Woods when the boys wanted to wander off? The father said, I want you boys to be in view. Where was the supervision when this little boy went into a creek that was fast moving, that had just had, because they had 10 inches of rain, and it was so swift that even the rescuers had a tough time remaining stable in that creek. Where was the supervision? Now that's the question. That's not an accusation. That is simply the question. Where was the supervision? Where was the supervision for the 5-year-old that ran in front of the car? Now we can find all kinds of reasons for making a big story out of this, because the gentleman gave her a lesson at a teachable moment. You talk about teachable moments. This was a teachable moment. She could have lost her life, and this gentleman said, and he would have had a tough time living with that the rest of his life if he had killed her. You know, I even get squeamish when I hit a squirrel in the street. Can you imagine what it would be like if you hit a little child in the street? That would tear you up.
I find the comment by the judge to be one of the most ironic comments in this case. The judge said that I can't read his mind. Well, if you can't read his mind, what are you going to assume the worst out of the guy for? If you can't read his mind and to admit on top of that that he did not mean her any harm, you know, and you can't read his mind, well, why if you can't read his mind, how are you going to assess and assume that the guy was up to no good?
What about innocent until proven guilty?
Yeah.
Good point. Good point.
If you can't read his mind, then obviously there should be a determination being made that he is not guilty of the crime that was being...
By reason of innocence.
There you go. There's a reasonable doubt. If you can't read his mind, it's obviously a reasonable doubt that he committed any crime in this matter. Just one of the many absurdities that you see coming out of the courtrooms these days. And Illinois, not only philosophically speaking, not only regionally speaking, but philosophically speaking, Illinois is not too far from Iowa in this regard.
No.
So to speak, they are right next to each other.
The laws are don't change a whole lot across borders. You get these campaigns and these drum beats that go into Congress and make all these regulations in something called CAPTA, a Child Abuse Prevention and Treatment Program, and all the states, just like we do with the seatbelt laws, or the speed laws, if you don't march to the tune of Congress, you can have your highway funds lifted. Well, they do that with the CAPTA funds, and so if you don't pass this particular law, Iowa could lose $33 million, you know. And as far as I'm concerned, we should have said long time ago, thumbed our nose at government and said, you keep the $33 million, we'll protect our children. But I think the key here is, if you want to protect children, that is a chore for parents. And if a child is harmed in some way, ask the question, where was the supervision? You see, every child in Iowa presumably has some kind of supervision. And if you can't maintain good, tight supervision at the local level, certainly an agency like the Department of Human Services is not going to be able to step in and provide that supervision for the kid that wants to run into the street or run into the creek or run into something that causes some immense harm to that child. I've got one short story here, and then I'm going to turn it over to Terrance, because he's got some stories about courtroom battles, about judicial concerns. According to a study by the Urban Institute in Washington, D.C., Iowa ranked among the last among the 50 states in placing children in foster homes belonging to relatives. You see, Iowa loves to be the first in the nation for this, the first in the nation for that. Well, they are the first in the nation for being the lowest at the bottom of the pile for placing children in foster homes belonging to relatives. The
That's
study
according
labels.
to the DHS state, right
uh,
out of their mouths.
No, that's Urban Institute in Washington, D.C.
Oh, okay.
The study labels Iowa one of the three least flexible states in the nation in placing state-protected children with relatives. Fewer than 1% of foster homes belong to relatives of children in the state care, according to the Iowa Department of Human Services.
So DHS isn't trying very hard to put the children into family homes.
No. So Iowa ranks at certainly at the very bottom of the 50 states for placing children in homes that belong to relatives. And I think there's a reason for that. Because if you place children in homes that are relatives, you might not have quite the influence that you would have with total strangers. So I think they want the total influence. Well, we're going to turn some issues that have to do primarily with the judiciary. And the reason why we're interested in the judiciary is because without the judiciary, there probably is not going to be a whole lot of change in the way we look at child protection, because the judiciary seems to be blocking everything that we are attempting to do. They seem to put their stamp of approval, and I know Terrance said that as he goes through the cases in the Supreme Court, there seems to be a whole long handful of parental termination cases. That should not be in a state the size of Iowa. We should not be having that much turmoil. But it is a problem, and the courts seem to be making it an even greater problem than we can imagine.
I remember
Okay,
asking a judge directly, how many terminations do you do every week? And she didn't answer me. She should have a pretty good idea, and I asked her twice. She doesn't want to admit it on camera, I guess. Okay.
Terrance.
Yeah, thanks a lot, John and Don, for having me on the show again. Appreciate you guys willing to allow me to be part of this effort to educate the public and to bring these issues to light. And I am the chief judge of the judges here in the state of Iowa, self-proclaimed, self-appointed. Somebody has to do it. I guess God chose me. And on a different note, a higher authority, I should say a related note. I got an article here from Judge Roy Moore, who was recently booted off the Alabama Supreme Court for putting the Ten Commandments near the courthouse.
Shame, Roy.
Now,
Shame, Roy.
I thought this was a very interesting article. Kind of puts his removal and his perspective in a whole new light. I'll just paraphrase this since we're short on time here. He starts, this is a July 4th article from Monday. All told, this court's jurisprudence leaves courts, governments, and believers and non-believers alike confused, an observation that is hardly new. And he's quoting Justice Clarence Thomas as he accurately described the Supreme Court's latest efforts of McCreary County versus the ACLU and Van Orden versus Perry to determine the public display of the Ten Commandments on state property are consistent with the United States Constitution. In McCreary County, the court ruled that 5-4 that the display of the Ten Commandments was unconstitutional under the Lemon test because they found a predominantly religious purpose, that is, to acknowledge one true God. Now, so to those that don't know, the Lemon test and all these other tests, these are basically a set of standards that they go by, a phrase of words that they use to measure a situation to determine whether or not it passes muster. So This is a Lemon test. They basically had it in this previous court case of Lemon. In Van Orden, faced with a monument of the Ten Commandments on the state capitol grounds in Austin, Texas, the court, rejecting the use of the three-part Lemon test and relying more on history, found 5-4 that the monument in that case was acceptable, partly because it had remained in place for nearly 40 years and was a passive display among 37 other historical markers on the state capitol grounds. Now, and I'll paraphrase the other part, the text of the First Amendment's religion clauses reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, but was quoted in its entirety only one time in all the writings of the justices. So, and I think that Judge Roy Moore does a good job in pointing out that the court cautiously avoids the words of the First Amendment in reaching their conclusion. They rely on these so-called tests and their subjective opinion. And where's the consistency? You have a Ten Commandments display here and Ten Commandments display there. Should be the same test, right? They said no. One we go by the Lemon test, the other one we're going to go on history. So who is at the helm of the Supreme Court? We don't know. It varies from time to time. How is the average ordinary citizen expected to know the boundaries of the Constitution when they're constantly changing, not only year after year, but in this case, in a matter of days apart? They basically follow one test and they don't follow the test when it's the same subject being brought before the court. So are we going to rely on history or are we going to rely on the Lemon test when it comes to these things? I don't know. But to me, it displays the absurdity of the courts. And we need to really not only focus more attention on the courts in this society, but we also should place more scrutiny on the judges that are in these courts so that we can have some sort of understanding and of common sense and fair play in this society. And that's why our organization here, Vote Iowa Judges Out, is advocating the removal of judges here in the state by people voting no. Next time you see that no next to the judge when you're in the ballot box, this coming November or the following November and the following Novembers after that, be aware that you have the right to just check no on these judges, because obviously they're not doing their job, and it's not making a whole lot of sense. And I hate to be really negative all the time, but that's exactly what the judiciary makes you when you take a clear and hard look at it. Iowa is supposed to be the phrase that when you come to Iowa, when you cross the border, Iowa, you make me smile. Well, the Iowa judiciary makes me frown. And there is some good news coming out, not of this state, but out of the state of New York. So I won't share all the thorns. I'm going to share a few roses here. How about that, John and Don?
Sounds good.
From the Jail News Journal, July 5th, which you can also get online. Go to jailforjudges.org, the website www.jailforjudges.org. Email them, say you want a copy of the journal. They're actually quoting a law.com article, and I quote the title, "Legal error and misconduct are not necessarily mutually exclusive." And a judge loses seat after showing shocking disregard for the law. New York State's High Court finds actions constituted removable conduct. And for all those that don't know, most states, even federal judiciary, have a judicial commission. Here in Iowa, we have the Judicial Qualifications Commission. Now, these bodies are supposed to investigate instances of misconduct and do something about them when it comes to judges. That doesn't happen all the time. The federal judiciary, I think, had in 2003, they only had one incident out of 755 complaints where they actually issued a reprimand against a judge. And it was a private reprimand, private admonition, I should say. And we don't know what that was. It could have been keep up the good work, for all we know. But New York is one of the rare states that is, so it looks like they are turning the tables on this trend of these commissions, and they're actually trying to forge ahead new paths and do something about these wayward judges that have for years have been operating under the radar, so to speak, and been able to escape much publicity and any sort of criticism, and have constantly relied on this thing called judicial independence, where they say that we should have the ability to do as we want, and because we're independent from everybody. Well, in a society that is a democratic society, that doesn't make a whole hell of a lot of sense, because this is by the people and for the people. So you can't be separated from the people and rule over the people. That's called totalitarianism. But anyway, in a harshly worded opinion, this is from the New York Law Journal, law.com. This Jelford News Journal cites this article off of law.com by John Caher, July 1st, 2005. In a harshly worded opinion, New York's Courts of Appeals Wednesday ended Brooklyn surrogate Michael Feinberg's judicial career. It held that his awarding of millions of dollars in attorney fees to a friend without demanding the affidavits required by law constituted removable conduct. The court said in a unanimous per curiam opinion that in rubber stamping with no oversight some $8.5 million in estate commissions to attorney Louis Rosenthal, Feinberg demonstrated a shocking disregard for the very law that imbued him with judicial authority. It rejected with apparent disdain Feinberg's defense that he had neglected to read the Surrogates Courts of Procedure Act, the SCPA, and was simply ignorant of his judicial responsibilities. Petitioner, this is a quote, petitioner disregarded the clear statutory mandates of his office repeatedly over the course of more than 5 years and 475 proceedings, educating himself on the SCPA requirements only in response to a newspaper's investigatory series, the court said. Quote, petitioner's consistent disregard for fundamental statutory requirements of office demonstrates an unacceptable incompetence in the law, unquote. Wednesday's ruling was a major victory for the New York Court Commission on Judicial Conduct, which has increasingly invoked its power to punish judges for illegal error and professional incompetence. There was never an allegation that Feinberg in any way personally benefited from misconduct, only that he chronically ignored legal requirements in approving millions of dollars in commissions for a close personal and political friend. Now, how many times has that happened here in Iowa? Can you think of any times where a judge has ignored clear statutory mandates, John?
Oh, by all means.
Yeah, okay. I think there was a case involving you with the camera going to a court proceeding, and the fallout of all of that. Ignorant deputy down there didn't know you had a court order to film the proceeding and hounded you around and used his authority to arrest you on a salaciously, I should say. Is that a correct term?
I think so.
Salaciously, he basically used his authority and unjust means to not only harass you, but arrest you for something he had no authority to do.
It's a term that he should have left at home.
And this happened about a year ago for those
Right.
that are new to the audience here.
March 24, I believe.
Yep. And what happened was, I think, that followed that, the same thing in that case was that the judge ignored the clear statutory requirements, and they ignored the constitutional requirements that the deputy was supposed to sign the affidavit, the complaining affidavit, under oath. This is something that's not new. I mean, this is a constitution. We're all bound by the Constitution, especially judges. They most of them, when they invoke their oath to office, they swear to uphold the Constitution and the laws of the state, or the laws of the United States. Yet, in this instance, the judge clearly did not even know the law, or he ignored it, we could say, because he went about and acted as if the deputy signed the affidavit under oath, and even stated that without any sort of indication on the affidavit that the judge, or that the affidavit was sworn in. Any 4th or 5th grade student that knows what a notary seal is could have told you that it wasn't under oath. Yet we have a judge that has went to a prestigious law school after going to another prestigious university for a bachelor's degree, and he can't read ordinary English. It says that the affidavits, complaining affidavits for people under arrest, have to be under oath. That we have it. I mean, we don't have the kind of authority, obviously, here, a commission, judicial commission, here in Iowa, that the New York Commission does, obviously. A lot of times what these commissions rely on is pseudo reasoning that we can excuse these judges because it was just an error. It was just a judicial error. Well, how many times does it take for a judicial error to become something so egregious that we have to do something about it? Well, according to the judges here, or the Judicial Commission here in Iowa, it must be a lot, because it's been almost 30 years and they've only removed less than a handful of judges. That, to me, is a horrible statistic. But thank goodness we do have commissions like we do in the state of New York, who say that legal error and misconduct are not necessarily mutually exclusive. Judges, I think, today rely too much on this judicial error excuse for their actions. These judges should know what they are doing. We entrust them with the ability to determine what our rights are, our property rights, our parental rights, our other legal rights when we go into a courtroom. And, you know, since they've got another actually it was about another $4.3 million that they got last year here in the state.
Right.
We should be all the more able to expect a high standard of legal rulings when we're going to a courtroom, instead of this, well, I didn't know, or, well, we can't read his mind, and, you know, where are these things kind of things coming from? It's insanity. But one of the other things I wanted to touch on real quick was this guy's excuse. This judge made an excuse. And I do have to also commend Attorney General Elliot Spitzer, who has also been pushing the cleanup of the legal establishment. Not only that, a lot of the financial establishments as well in the state of New York and across the nation. But this judge's excuse for doing this so many times over the year and ignoring the clear statutory mandates was that it was a discretionary thing. And not only that, but he had a legal brief that was filed on his behalf by an association that supports the judges. I'm trying to find the part in the article here where it actually says that, but there's like there was a organization that's closely aligned with judges here in the state of New York, which insisted that the commission had no business second-guessing the discretionary actions of a judge. Well, if that was the case, at what point are we to tolerate these clear acts that represent a total disregard for the law? Are we just to say that everything that the courts do in disregard for the law is discretionary? This is the kind of insanity that we get with these commissions, and I'm glad that the New York State Commission on Judicial Qualifications seen through this weak defense and went ahead and sanctioned the judge. Too bad in Iowa we don't have the kind of commission with the same integrity and the same courage and the same guts.
That's right.
That's my comments on that.
Okay.
Did you have a comment on this, Judge John or Don?
I just say amen to what you've said here. We seem to have a difficult time in our judiciary with such things. Well, you mentioned one of them is we have these little games that they play, like the lemon law. We'll have certain tests that they set up in order to carry out their particular brand of opinions, and those are just schemes. They have nothing to do with real law. Well, Don, we've had here in Iowa something called Violence Against Women's Act, and it's time that that they be refunded because they have all kinds of marvelous things. You have a story about Violence Against Women's Act and some of the reaction that's taken place as a result of some of the deficiencies in that act. Don, go ahead.
This article is written by Lisa Scott, attorney at law. Picture this: ordinary citizens arrested in the middle of the night, thrown in jail on false charges, never seeing the inside of their homes again. Show trials with predetermined outcomes. Dissidents forced into treatment for politically incorrect thoughts. Does this describe Stalinistic purges, totalitarianism, repression, the USA Patriot Act in action? You ever heard of the Patriot Act? No, this nightmarish scenario is our current domestic violence system. Introduced in the 1980s with good intentions, these laws have mutated into the system of repression, power, and control, manipulated by the domestic violence industry and exploited by vengeful spouses seeking advantage in divorce and child custody. The crowning achievement for the victim industry was the passage in 1994 of VAWA, the Federal Violation Against Women's Act. VAWA codifies gender-based myths that domestic violence, the short version is DV, domestic violence, is virtually always committed by men against women. VAWA is for reauthorization is up for reauthorization in 2005. VAWA was based on lies and distortions about the true extent of intimate partner violence. Yet it continues to be funded at astonishing rates. Feminist groups, led by the domestic violence quote-unquote scream queens, tout hysterical claims such as the leading cause of emergency room visits by women is domestic abuse, unquote, and, quote, 95% of victims of domestic violence are women, unquote. The government's own statistics contradict these ubiquitous factoids, yet Congress can't help pandering to the women's voice with a billion-dollar gravy
How about
train.
a women's vote? That's more important than their voice.
Do you think they would vote instead of voice it? Okay. So they're going to vote about this $1 billion gravy train. The Justice Department's 1998 Intimate Partner Violence report reveals that 1/3 of total domestic violence murder victims are male. Further, less than 1% of females and males are victimized each year. Hardly an epidemic justifying a monstrous government system. Let me requote that sentence. Further, less than 1% of females and males, both genders, are victimized each year. In today's domestic violence police state, it's expected the woman is the victim. All she has to do is call 911 and report her husband assaulted her. In many cases, she conveniently fails to mention she slapped, kicked, punched, or pummeled him to the point that he pushed her away. I'm sure that happens a lot. And that's not to say that men aren't a problem too, but
Yeah.
as a
Right.
yes, Terrance.
I was just saying we're going to run short on
Okay.
time here.
As a family law attorney for 17 years, I have experienced the DV system personally. Every example cited in this article has happened to one of my clients. The stereotype that the man is always the abuser ensures he has no chance of being believed when he says he is the victim. The police take him to jail, and in many cases, he never goes home again. The next scenario seen in his nightmare is being served with an order for protection, oriented to immediately protect victims of severe abuse. Protection orders have become weapons of mass destruction in family courts. Drive-by protection orders obtained ex parte, with the accused not present. Women can go to the courthouse and get that ex parte real easy. It almost always prohibits contact with his children and presence at the family home, virtually guaranteeing full custody to the accuser. After 14 days living in a van down by the river, the accused gets a hearing, an opportunity to be heard. In reality, it is a show trial with a predetermined outcome. Whenever a woman claims to be a victim, she is automatically believed. No proof of abuse is required. Judges with do something disease, afraid of some real victim. John.
Okay, we didn't get all the way through the story, but perhaps we can attack that another time. Here's some numbers that you might like to call. I was interested in getting that story in because of its effect in our society. Here's a couple of numbers that you might like to contact. We'll see you